Most people think Supreme Court gun cases change laws overnight. A ban falls, a right expands. Something becomes legal everywhere or illegal everywhere. But that is not what actually happened with the most important gun decisions of the last few years. What really changed was quieter, more technical, and far more impactful in everyday life. The Supreme Court didn't just rule on guns. It rewrote the rulebook for how gun laws are judged. And that shift has already changed how permits work, where you can legally carry, what restrictions survive court review, and how easily ordinary people can accidentally break the law. Many gun owners didn't notice it at first because the change wasn't dramatic. It was procedural. But in real life, it may matter more than any single ban or repeal. To understand why, we have to step back to what gun law looked like before this shift, and how courts used to decide whether a gun regulation was constitutional. For decades, most lower courts applied something called interest balancing. Judges would weigh an individual right against the government's claimed public safety interest. If a law was said to promote safety, courts often upheld it, even if it placed heavy restrictions on ordinary law-abiding citizens. This approach gave lawmakers and regulators wide discretion. If they could justify a rule as reasonable or beneficial, courts frequently deferred. That changed in 2022 when the Supreme Court decided New York State Rifle and Pistol Association versus Bruen. The case itself focused on public carry permits. New York required applicants to show proper cause, a special individualized reason, to carry a handgun in public. The court struck that system down. But the most important part of the decision wasn't just the result. It was the test the court announced. Under Bruen, courts are no longer supposed to weigh costs and benefits or balance public safety against individual rights. Instead, judges must ask whether a modern gun law is consistent with the text of the Second Amendment and with the nation's historical tradition of firearm regulation. In plain terms, the government now has to show that a challenged gun law fits within a historical pattern of similar regulations from the founding era or early American history. Not identical laws, but relevant analogies. If the government can't do that, the law is vulnerable. As of January 2026, this text, history, and tradition test is the controlling standard in Second Amendment cases, and that standard has quietly reshaped multiple legal battlegrounds at the same time. The first area where people noticed change was public carry permits. Before Bruen, several states used what were called may-issue systems. Even if you met every formal requirement, officials could deny a permit unless you convinced them you had a special need. Bruen ended that. States can no longer require applicants to prove extraordinary danger or unique circumstances just to exercise the right to carry. In that sense, permits became easier to obtain in many places. But the story didn't end there. In response to losing discretionary control over permits, several states shifted their focus. Instead of deciding who could carry, they began expanding where carry is prohibited. Legislatures created long lists of so-called sensitive places, locations where firearms are banned regardless of whether the person has a valid permit. Some of these locations are familiar, like courthouses or certain government buildings. Others are much broader and more complex. Schools, medical facilities, public transportation, entertainment venues, and areas open to the public but privately owned. In some states, carry is banned by default unless the property owner explicitly allows it. In others, carry is allowed unless the owner posts a prohibition. The rules vary widely. The practical result is that the legal risk shifted. Before Bruen, the danger was being denied a permit. After Bruen, the danger is carrying into the wrong place. A person can now be fully licensed, trained, and compliant, and still commit a serious offense simply by crossing an invisible line. This is not hypothetical. Mixed-use buildings are one of the most common traps. A single structure might contain medical offices, government services, private businesses, and residential units. One floor may be restricted, another may not. The law often does not clearly explain where one legal zone ends and another begins. Elevators, shared lobbies, and parking structures can all fall into gray areas depending on state law. For everyday permit holders, this means legality now depends heavily on location awareness. It's no longer enough to know whether you're allowed to carry in general. You have to know whether you're allowed to carry exactly where you are standing. And those rules can change quickly through legislation or court orders. According to current state law in several jurisdictions, violations of sensitive place restrictions can carry felony penalties, even without malicious intent. That's why misunderstanding these rules is one of the highest real-world risks after Bruen. Carry permits are easier to get, but carry maps are more dangerous and more confusing than before. The second major change that many people misunderstood involves domestic violence restraining orders and firearm prohibitions. After Bruen, there was a widespread belief that many existing restrictions would automatically fall. That assumption turned out to be wrong. In United States v. Rahimi, the Supreme Court addressed a federal law that prohibits firearm possession by individuals subject to certain domestic violence restraining orders. The defendant argued that under Bruen's historical test, this restriction was unconstitutional. The court disagreed. The court held that historical tradition allows for the temporary disarmament of individuals who have been found by a court to pose a danger to others. Importantly, the court clarified that Bruen does not require the government to point to a law from 1791 that is identical to the modern one. Instead, courts may rely on historical analogies, earlier practices that reflect a similar principle, such as disarming dangerous individuals for limited periods. This distinction matters. The court emphasized features like duration, scope, and process. A temporary prohibition tied to a court finding of dangerousness is more likely to survive constitutional review. A permanent, blanket, lifetime ban applied without individualized findings is much weaker under the Bruen framework. As of January 2026, Rahimi stands for a critical clarification. Bruen does not eliminate all gun restrictions. It reshapes which ones are defensible. Laws that are narrowly tailored, time-limited, and focused on demonstrated risk have a stronger chance of being upheld. Laws that are broad, permanent, and untethered from individualized assessments face greater scrutiny. For the public, the practical takeaway is that not every restriction challenged under Bruen will fall. The outcome depends on how closely the law aligns with historical practices and how carefully it is structured. Assuming that all firearm prohibitions are invalid, under the new test is a mistake that can lead to serious legal consequences. The third change is one that many people heard about but often misunderstood. This involves bump stocks and the Supreme Court's decision in Garland v. Cargill. At first glance, it looked like a major Second Amendment ruling. In reality, it was primarily a case about statutory interpretation and agency power. The court struck down the ATF's bump stock ban, not because bump stocks were declared protected arms under the Second Amendment, but because the agency exceeded its authority. The statute defines a machine gun in a specific way. The court concluded that the ATF stretched that definition beyond what Congress actually wrote. Agencies, the court said, cannot redefine statutory terms to create criminal liability. This matters far beyond bump stocks. Federal firearms law relies heavily on definitions. What counts as a firearm? What counts as a receiver? What qualifies as a machine gun, a short-barreled rifle, or a silencer? Even terms like readily convertible carry enormous legal weight. Under current law, a change in interpretation, not a new statute, can suddenly transform a previously lawful object into a regulated or prohibited one. For ordinary people, this creates uncertainty. Something that is legal today may become illegal tomorrow through regulatory reinterpretation, even before courts weigh in. Cargill reinforces an important principle. Agencies are limited by the words Congress uses. But it also highlights the risk that comes from relying on informal guidance or assumptions. Compliance depends on definitions, and definitions can be contested, revised, or overturned. This is where the first half of the story leaves us. The Supreme Court didn't issue one sweeping command. It changed how courts analyze gun laws, and that change is still unfolding. Public carry became more accessible, but more location-dependent. Some restrictions survived because they fit historical patterns. Others fell because agencies went beyond their authority. And the real-world risk for ordinary people increasingly comes from complexity, classification, and geography, not from headline-level bans. The rest of the story involves unfinished cases, unresolved bans, and a legal landscape that remains fractured across state lines. And that's where the uncertainty grows. The fourth shift happened with far less public attention, but it has significant consequences for builders, hobbyists, and ordinary buyers. This involves so-called ghost guns, unfinished receivers, and firearm kits, and the Supreme Court's handling of challenges to expanded federal regulation. These regulatory battles did not begin in a vacuum. Federal agencies have taken different approaches to firearm classification across multiple administrations, including during the Trump administration and the administrations that followed. What changed in recent years is how much those agency interpretations are now being tested in court. In ATF versus Vanderstock, the Supreme Court allowed federal regulation of certain kits and unfinished components to move forward. The key issue was classification. The government argued that some items being sold were close enough to functional firearms that they could be treated as firearms under existing law. The court did not declare homemade firearms illegal. Instead, it accepted that certain parts, when sufficiently complete or marketed in a particular way, can fall within the statutory definition of a firearm. This reflects a broader legal tension that has existed across multiple presidencies, including under President Donald Trump. During the Trump administration, the federal government emphasized enforcement through existing statutory definitions rather than sweeping new legislation. That approach placed heavy weight on how terms like firearm, receiver, and machine gun were defined in law. What has changed since then is the level of scrutiny courts now apply to those definitions. After decisions like Bruen and Cargill, agencies face tighter limits on how far they can stretch statutory language, regardless of which administration is in power. Legality in this area now depends on several factors: how complete the item is, how easily it can be converted into a working firearm, how it is sold and advertised, whether the seller includes tools, instructions, or bundled components, and how state law interacts with federal rules. As of January 2026, this remains one of the fastest-changing areas of firearms regulation. Court orders, injunctions, and agency guidance can alter compliance obligations quickly. For builders and hobbyists, the risk is not intent, but classification. An item purchased legally under one interpretation may later be reclassified, creating potential legal exposure without any intentional change in behavior. This illustrates a broader theme emerging after Bruen and related cases. The biggest legal risks increasingly come from definitions: what counts as a firearm, what counts as possession, what counts as manufacture. These are technical questions, but they carry criminal consequences. The fifth major area is also the one many people ask about most: assault weapon bans and magazine capacity limits. Here, the story is not resolution, but uncertainty. These bans have existed under different political conditions, including during the Trump presidency, when some states expanded restrictions while others moved in the opposite direction. What matters legally is not which administration was in office, but how courts now evaluate those laws under the Bruen framework. The Supreme Court has not yet issued a definitive ruling resolving the constitutionality of assault weapon bans or magazine limits nationwide. When the court declines to hear a case, the lower court's ruling remains in effect. That does not mean the Supreme Court agrees with the outcome. It simply means the court chose not to intervene at that time. As a result, bans remain active in certain states and not others. Some lower courts have upheld restrictions. Others have struck them down. Appeals continue. Injunctions come and go. For the public, this creates a fragmented legal landscape that persists regardless of changes in political leadership. According to current state law, a magazine that is standard in one jurisdiction may be prohibited in another. A firearm configuration that is lawful in one state may be restricted across the border. Even transport rules can differ significantly. This fragmentation creates high-risk scenarios, especially for travelers. Carrying standard magazines across state lines, entering a state with different default carry rules, assuming reciprocity applies when it does not, or misunderstanding sensitive place laws that differ sharply from one jurisdiction to another. The absence of a Supreme Court decision does not freeze the law. It means uncertainty persists. And uncertainty, in legal terms, often creates the greatest compliance risk. Taken together, these developments show that Bruen was not an endpoint. It was an engine. It changed how cases are analyzed, not how quickly they are resolved. That shift affects laws created under Republican and Democratic administrations alike, including policies originating during the Trump era and those adopted afterward. New carry rules, location bans, training mandates, and classifications continue to be tested in courts across the country. That brings us to practical guidance, not as legal advice, but as general awareness for responsible permit holders and lawful owners. First, it is no longer sufficient to rely on headlines. Many cases that affect firearms are not Second Amendment cases at all. Some are statutory interpretation cases. Others involve agency authority. Some turn on administrative law rather than constitutional rights. Understanding which category a case falls into matters. Second, location awareness is now critical. After Bruen, many states shifted regulatory power from who may carry to where carry is prohibited. This means permit holders should verify current sensitive place lists and default carry rules before entering unfamiliar buildings or jurisdictions. Mixed-use spaces deserve special attention. Third, travelers should treat each state as legally distinct. Reciprocity agreements, magazine limits, transport rules, and sensitive place definitions vary widely. Crossing a state line can change what is lawful, even if the individual and the equipment remain the same. Fourth, builders and kit buyers should stay current on classifications. Federal and state definitions can change through regulation, litigation, or enforcement guidance. Purchasing items that are near the boundary of regulated status carries additional risk. Fifth, remember the lesson reinforced by recent Supreme Court cases. Courts may uphold restrictions that are temporary, targeted, and tied to findings of dangerousness. Broad assumptions that all restrictions will fail under the new legal framework are inaccurate and potentially dangerous. Finally, staying legal increasingly requires staying informed. Injunctions can pause enforcement. Appeals can reinstate rules. Agency interpretations can shift. What was accurate under one administration, including during the Trump presidency, may not remain accurate today. The final takeaway is this: the Supreme Court did not simply change 5 gun laws. It changed how gun laws live or die. The biggest risks now come from location restrictions, definitions and classifications, state-by-state differences, and unresolved litigation. For responsible gun owners, the path forward is not speculation or assumption. It is verification, checking official state sources, confirming reciprocity, understanding where carry is restricted, and recognizing that laws change, sometimes quietly. Because in the current legal environment, rights and responsibilities move together, and laws change. Information must be current.